Okay, good morning, everybody. Welcome to Wednesday morning, and this is the latest in the QS series. It's an update to Conor's presentation at the beginning of the year on loss and expense claims. So Conor's just going to give us an update on the latest situation, particularly bearing in mind COVID, etc. So as usual, if you have any questions for Conor, if you can use the Q&A panel in the toolbar at the bottom, and then he'll address these at the end of his presentation. And as always, if you've got any questions you don't want to raise during the presentation, feel free to email him afterwards. His contact details are on the slides. So without any further ado, Conor, the floor is yours. Please take it away.
Very good. Thank you, Julie. Good morning, everyone. Hope you're all well. You're very welcome to the latest in the QS series. Now, this is an update in relation to loss and expense claims. We previously looked at this back in April. There's been a couple of questions raised at the time, so we're looking to encompass all of those today and just give you the latest legal position on loss and expense. So we get going. There's me, there's a bit of my profile, just a bit of housekeeping. As Julie said, you know, please send any questions, anything at all, just get them into the Q&A box, and we'll get to them. And obviously this is not legal advice, it's more educational, more just trying to pass on some knowledge from experience, both as a quantity surveyor and as a trainee solicitor. Okay, so yeah, just an introduction. So yeah, obviously, look, you know, I hope you're all well. You know, the coronavirus situation, and look, there have been a lot of questions in relation to, you know, COVID-19 and loss and expense. Dealt with a lot of those 2 weeks ago in a separate seminar, which is available on our website. So yeah, I mean, I'll touch on it again today, but if you do need more information on it, you know, please feel free to go back and have a look at those that previous seminar. Okay, this webinar is split into three parts. So first of all, we're going to look at, you know, what is loss and expense. You know, it's a term that's used very frequently in construction, but you know, what does it actually mean and how does it arise? So we're going to look at that first. Then we're going to deal with liability. How do you successfully get an application for loss and expense off the ground and under your contract? And then we look at quantum. We look at the typical heads of recovery that we tend to go for as part of our loss and expense recovery. And you know, finally we'll wrap up with a conclusion and some questions and answers. Okay, part one. So what is loss and expense? So as I said here, is that it's loss and expense. It's not a defined term. It's generally taken to mean, you know, it's synonymous with damages, common law, compensation events in NEC. So you know, they're all treated as the same. I mean, one of the most helpful quotes on loss and expense and damages generally is a much quoted dictum of in Robinson versus Ahern. Now this is in 1848, so it's over 170 years ago. But it's, I mean, still good law to this day, and it says that the general principle of contractual damages is to put the claimant in the position they would have enjoyed if the contract had been performed. Consequently, the claimant should not be put in a better position than they would have enjoyed had the contract been performed. So, you know, you can see the real message there is to reimburse the contract, you know, to the claimant to the position he would have been in, but not to better his position, then, you know, better the position he would have enjoyed if the contract was performed. So, I mean, I remember this is one of the key principles that I looked at even when I was studying to be a quantity surveyor in my undergrad. So, so yeah, it's still good law. It's still a very important principle to bear in mind when you are making applications for loss and expense. It was followed up. I mean, it's been touched on in many cases. I mean, you know, rate versus PH&T considered a question also, and held to mean the equivalent of damages at common law. So, you know, there you go. Just remember that to be put back in the position you would have enjoyed had the contract been performed. So that's the you know, that's the key definition to bear in mind when dealing with loss and expense. How does it arise? Entitlement arises under contract, but only when the payment is not reimbursed elsewhere in the contract. So that's, so just remember that principle, not reimbursed anywhere else. So what he's saying is that, loss and expense occurs, following the reimbursement of obviously your contract sum, any provisional sums that you may have, any variations, and any day works. And so I like to think of loss and expense as the residue. That's the residual costs that we cannot recover anywhere else in the contract. And do bear in mind that under your contract it says that you should try and apply for variations before applying for loss and expense. You can see it there. It's on the hierarchy before we get to the residue, and it's a very helpful piece of advice to bear in mind, is like not always to be reaching straight away for loss and expense, but rather think about your variations. Think about has there been a change in the conditions, or has there been greater restrictions, or has the client just obstructed you in carrying out the works? Like a lot of those typical items can be recovered as variations, where you go into your variation clauses and deal with fair allowances for any changes in conditions. So do bear that in mind, and do remember that loss and expense is treated as the residue under the contract. Okay, entitlement can also arise under common law. So where there is entitlement under the terms of the contract, one's common law rights are retained unless they have been expressly excluded. In brackets, frequently restricted under schedules of amendments. So usually, thinking about a JCT contract, if you look at clause 4.23, or basically the final clause in section 4 of your JCT contract, that would state that your common law rights have been preserved. Now, what we see very, very often is that that's attempted to be altered in the schedules of amendments, because basically clients don't want to be dealing with claims in common law. They say that the reimbursement of loss and expense or damages shall only be dealt with under the loss and expense section of the contract, and basically seek to prevent any application under common law. Very important when you are signing up to condition precedents for loss and expense notices, because if you fail to give the notices within the required time frame, then you lose your entitlement to apply for loss and expense under the contract. And if there is a clause saying that your common law rights have now been excluded, then you may well be in a position that you're unable to make an application, or it doesn't get off the ground. So so do bear that in mind. Look out for that clause 4.22. It typically is, and that's the reason why the schedule of amendments is seeking to alter that position. So do keep an eye out for it, because it is important, as I said, especially when there are condition precedents involved. Okay, so matters material affecting the regular progress of the works. Loss and expense, it typically occurs, if you look at your JCT wording, there's basically two headings. It says it occurs through either deferred possession, so that's where you haven't been given possession within the window stated in your contract. Usually that window is 6 weeks. We've seen that window being extended quite frequently lately due to the uncertainty around COVID-19. We've seen clients try to extend that to 3 months. That's generally, so they basically double that window. Now that can have an effect, because during that window, if costs increase, how are you going to deal with that? So do think about how your loss and expense clause operates in such circumstances. Or the second ground is where the regular progress of the works has been affected. Now this is the more popular heading for recovery of loss and expense. So regular progress has been affected. So but in order to actually understand that, we need a good understanding of what the intended progress of the works was going to be. and obviously then you know, you're submitting an application for loss and expense on the basis of what has changed. So yeah, key to everything we do is they need to have a good understanding of how the project has been priced and programmed in the first place. Okay, so just on submissions here. So obviously try and act as soon as you become aware. That's whether you have, that's whether you have lost condition precedents or not. So you know, you got to submit your notice. So you want evidence that is reasonably necessary to show the regular progress has been effected. You want to be updating this monthly, and you want to set out the case in as much detail as possible with correct references back to the contract price, program, schedules of clarifications, anything else that you may seek to rely on that clarifies your position under the contract, and then obviously you seek to rely on that to demonstrate the change. Now, one of the questions that I get asked, you know, very frequently is you know, what wording is needed for your notice. You know, my recommendation is that you keep that quite simple. I mean, you don't need to use overly legalistic language when you do it. Now, I mean, you can if you wish to do so, but I experienced when I was a QS, I used to try and keep the language quite simple. Try and make it sound, you know, make your notice sound like the language that you would use if you were telling them directly. And you know, at the same time, it's always good to have a conversation in advance of submitting your notice, just so that your client is aware of the issue and they'll be expecting the notice as well. That's just good communication, and I think that it just bodes well to improve the relationship generally. So yeah, look, we've many examples of notices that that we use, and we've got formal and informal, and if you would like any of those, then please don't be afraid to ask. So response to the loss and expense assessment. So usually the responding party, they usually have between 8 and 12 weeks to make an assessment. But do bear in mind that's from the period when they have the particulars, that they're in a position to understand what it is that the application relates to, and also what sums you're actually seeking to recover. So this is relevant matters under a JCT contract. I mean, these are the grounds which we need to attach our loss and expense application to. So what it says here, the typical grounds are variations, so that's where you may have some loss and expense. Again, residue which cannot be recovered under your variation clause should fall into the loss and expense part. So yeah, you may end up with a change for either from a client instruction or just from something that has happened on site. That says part variation, part loss and expense happens very often. Second one is architect's instruction. So where the work has been postponed, you'll have running costs based on whatever the reason for postponement is. Also provisional sums. There may be some aspect of provisional sums that is not covered under the provisional sums clause in section 5. So you may need to apply for that as loss and expense also. Opening up or inspection of the works is treated as a loss and expense event as well, especially in the event that the work that the client wished to see is in line with the contract. I mean, certainly that should be applied for as loss and expense. The third ground is execution where approximate quantities are not reasonably accurate. So yeah, you may have an element of loss and expense associated with that. And the final one here is what we call the catch-all loss and expense clause. So this relates to any impediment, prevention, or default, whether by act or omission, by you can say contractors persons, or employers persons, or basically the upstream party. And that's that can relate to the most common issue that occurs here is the issuing of late information, and the impact that has on productivity and basically plant and labor costs. Generally does get covered under this impediment, prevention, or default by the contractors persons. because the contractor's persons does obviously include the contractor's team. Similarly, the employer's persons includes the employer's team. So any information issued late by the architect, structural engineer, or any other members of the design team, any loss and expense associated should be should be applied for under this impediment prevention or default, the catch-all clause as we refer to it, under the JCT contract. Okay, so that's basically, you're setting yourself up, getting, understanding what loss and expense is, and now we've got to move on to liability. So this is the second part, and basically what it says is that in order to be entitled to loss and expense, there must have been a breach or a change of the original contract intent. Now that's not, that sounds obvious, but it's obviously something that's very important. I mean, again, it goes back to what your original contract intent. And what I'm saying here is that this requires a clear understanding of what we were contractually required to do, and that includes a strong understanding of price and program. This is the cause of the loss and expense, and also the other party must be responsible. And when we say they must be responsible, then what we got to do is, under a JCT contract, is go back into our relevant matters and attach the event that has caused the loss and expense to one of those grounds. But what you can see here is that it's really important that it's clear what the contract intent was, as much as possible, because that makes it so much easier to apply for your loss and expense, because you're showing what your intentions were, and obviously actual events will speak for themselves as they unravel on site. If you haven't stated what the contract intent is, it makes it more difficult in your application, because you're basically having to infer a position, and it's going to be, that is going to lead to a situation where there's going to be a lot of, toing and froing between the parties, because ultimately the upstream party will say that you're just basically creating a position that entitles you to additional money. You want to avoid that, and the easiest way to do that is to have a clear intent inside in your contract. All is the easiest way, and it'll avoid protracted negotiations at a later date. Obviously, it does, as I say again, clear understanding of your price and program. It underpins everything. It underpins variations, loss and expense, everything that has a commercial impact on the project. Without a strong understanding of your price and program, you may not recover this. You could have genuine entitlement to loss and expense, but you may not actually be applying for it. So obviously that's a position you don't want to be in. It does happen. I mean, it does happen where main contractors have their own claims where subcontractors haven't even thought about it yet. So that clear understanding of your price and program is key and underpins all of this. So we got to touch on causation. Now, the leading case in causation, remains the Hadley versus Baxendale. Again, this case is over 150 years old, but it's still a good law. Now, there's two limbs to this. So damages available for a breach of contract include those that may fairly and reasonably be considered arising naturally from the breach of contract. So those fairly and reasonably considered to arise from the breach. Now, the second limb is that such damages as may reasonably be supposed to have been in the contemplation of the parties at the time the contract was made. So that's those damages that were, that are in contemplation of the parties. If a loss could not be foreseen in formation of the contract, then the general rule is that it cannot be claimed. And I think it's helpful just to give some brief background to Hadley versus Baxendale here as an example of if the loss isn't foreseen, then the general rule is that it cannot be claimed. So Hadley versus Baxendale, basically Hadley owned a mill and they had a crankshaft. Now they only had one crankshaft, and that crankshaft broke. So they basically they look for somebody to fix the crankshaft. They appoint Baxendale. Now, but they never told Baxendale that it was their only crankshaft. So Baxendale had no knowledge that, all the while they were trying to, fix the shafts, that Hadley's plant was basically not operating. So it wasn't in their contemplation because Hadley had never told them. And it was reasonable for Baxendale to assume that, considering the shaft is so important to Hadley's business, that they would have had more than one crankshaft because of the likelihood that the shaft, considering it was used so much, that it was likely to break. So Hadley never communicated that fact to Baxendale. Baxendale ends up returning the crankshaft late, which happens, quite frequently. And then, Hadley then seek to recover what's called special damages from Baxendale. And those special damages is basically all profits arising from the fact that their plant was shut down for the duration that Baxendale had the crankshafts. Now, so those special damages, those profits, basically, they were treated as special damages, but they were not communicated. And what the court said is that where they weren't communicated, or you didn't make the the other side aware, then it wasn't in Baxendale's contemplation, and as a result, the claim for profits failed. So you can see there the importance of making it clear what the losses are in the result of late completion. Now, typically we talk about this when we're discussing LADs. I actually had this yesterday where I was reviewing a subcontract for a client, and basically the main contractor had gone to great lengths to explain the level of LADs that they were liable for under their contract with the employer. And again, the reason for that was, in the event that the subcontractor was late completing, then the main contractor would have a claim for their own LADs under their main contract, but also then they would be looking for their own costs arising from the late completion by the subcontractor. So again, it's like following the second limb of Hadley versus Baxendale, that causation issue. The main contractor was being very clear what the costs are, or what the losses that ought to be in the contemplation of the parties when signing the contract. So yeah, very important, element of causation to bear in mind. And this is a key area to focus on in order to, succeed with your loss and expense. You should be going for everything that is in the contemplation of the parties at the time the contract is made. If you have communicated that, then you stand in good stead with you submitting a successful application for loss and expense. So yeah, so that's causation. We've got to touch on global claims here, because we do see a lot of loss and expense, typically can end up as global claims. So in some circumstances, the contractor may find it difficult to demonstrate that a particular breach by his employer caused a particular loss to the contractor. In such a situation, the contractor may try to claim its loss and expense in a single rolled up claim, which is commonly known as a global claim, or a total cost claim. Now, these claims are terms used to describe a contractor's claim that identifies a number of causes of delay and or disruption and can seek to link them to the contractor's total. From this figure, the employer's net payment is deducted and a claim for the balance is made without attributing actual costs to individual events. So this is the classic global claim where the contractor suffers delay and disruption, is unable to actually satisfy link events to his additional costs, and basically just ends up rolling everything up into one claim. I've seen it in the past where they basically roll up their entire cost for the project and deduct the monies paid to date, and that's the value of my claim, almost trying to go back to a cost plus contract when yeah, that was never the intention of the parties. I mean, look, it doesn't happen so much anymore, but global claims, do happen. But I mean, what the message I'm trying to get across here is that, and we'll come on to it in the case of Walter Lilly versus Mackay. It's saying that you're not attributing actual costs to individual events, and when you're in that position, it just makes it more difficult to realize the proper value of your claim. Because if you don't understand the proper value of it in the first place, it's going to be really, you're always on the back foot to try and to maximize potential recovery, or also actually understand where it is such sums have been lost. Because very often, if you can get into the detail, you'll generally see that the losses are boil down to 2 or 3 main arguments, and if you can focus on those and strengthen those, then you're better off to do that and give yourself a better chance of achieving the highest possible return on your loss and expense. So this is some background into Walter Lilly versus Mackay, because this was a claim that back in 2012, and basically it was seen as it could potentially open the floodgates in relation to global claims, but that was almost a misinterpretation of what was actually said in the case. And Mr. Justice Aikenhead, he set out his view that Walter Lilly's claim was not, on a proper analysis, a global or total cost claim. And this was despite the fact that the parties had initially assumed it would be regarded by the court as such. So the reasons Justice Aikenhead said it wasn't a global claim was as follows. Walter Lilly's final pleadings did identify a comprehensible case in relation to delay. Their case for extended preliminaries and profit and overhead was related solely to the periods of delay for which it asserted that it was entitled to extensions of time. So there you can see that that they're entitled to an extension of time, so they have the relevant events, and what they've done is they followed through with their relevant matters as well under the contract, which entitles them to loss and expense. So he's saying that that's absolutely the way it should be applied. The subcontractor claims are largely based on extension delay, and to the sums actually paid, if not yet paid, due to the relevant subcontractor. So again, a significant part of this claim was the fact that you had prolongation costs as a result of valid extension of time applications. So again, in such circumstances, you'd be applying for that under your impediment prevention or default clause, your catch-all loss and expense clause. That's exactly what Walter Lilly did. So, I mean, what's going in on the assumption that the court would treat their claim as a global claim? That's not how the court saw it. They saw that there was that the links between events and losses were well demonstrated, and as a result, then it wasn't to be treated as a global claim. It was to be treated as loss and expense under the contract. So what we're saying here is that global claims by contractors claims by contractors for loss and expense must be proven as a matter of fact. What this means is that the contractor has to demonstrate on the balance of probabilities, so your civil proof, that events occurred which entitled it to loss and expense. Those events caused delay and/or disruption, and such delay or disruption caused it to incur loss and expense. And the entire claim fails if loss is caused by the applicant. I mean, that's the key risk with global claims, is that if the applicant has got costs in there which can be clearly linked back to their own shortcomings under the contract, then the risk is that the entire global claim will dissipate. It will fall away. So the key point here and the key message is that you want to identify the events, you want to show they cause delay and disruption, and you want to show that you want to link that delay and disruption then back to your headings under your relevant matters under the contract. If you can do that, you're giving yourself a far better chance of being successful in recovering your loss and expense, and obviously maximizing your your potential value from loss and expense also. So so try and avoid global claims as much as possible. I mean, they still happen, but from experience, I've seen that if you can, where you're able to link events to additional costs, and you can demonstrate that, then you're going to be more successful in the application. That's the position you want to be in. You want to show that you understand it. You want to show the other side that that they are responsible for these losses, and then move on to quantum, and then move on to what headings are we discussing here as part of my loss and expense application. So that leads us nicely into the third and final part of this morning's webinar, and so we're going to look at quantum here. So the typical heads of loss that we see in loss and expense. So briefly, they're preliminaries, general disruption, head office overheads and profit, the finance charges, and also the costs of collating the claim itself. So preliminaries. Now, two main, I suppose, terms that we deal with in loss and expense in relation to preliminaries. And the first is prolongation. So prolongation basically is where the program has been prolonged, or you're on site for a longer period of time. And as a result, so what you want to be doing is submitting your extension of time, linking that to your relevant events under, say, for example, section 2 of your JCT contract, but then, linking that extension of time, linking the cost to that to your prolongation costs, because obviously you're going to have resources on site, and generally we're talking about prelims, so your site supervision, your project manager, site engineer, you could have gatemen. So all of those costs that all of those the guys that you need to be able to service the site to make sure it's it runs properly. So that'll generally be what you'd look for in your as part of your labor recovery, and then generally your standing plant. So basically, formulate your list of standing plant that I have on site, or plant price in your preliminaries as well. Another point, just while I'm on it, is that bear in mind that you're looking at the recovery of your cost. I mean, it's not necessarily recovery as per your rates in your preliminary section of your contract sum. You go back to costs in this case, because again, you go back to Robinson versus Harman and the golden rule, which says you should be put back in the position you would have been in if the contracts had been properly performed. So that puts you back into your cost position, plus a fair allowance for for overhead and profit. And that's fair, because for example, sometimes if you have got inflated rates in your preliminaries, if you were to continue price your prolongation costs in line with that, then you would have a betterment, and you would realize more profit, and that's not what the purpose of loss and expense is. So bear in mind that period of prolongation is is to be valued at cost plus overhead and profit. Similarly, you could have a case where some of your preliminaries were were priced, but the cost on site might be greater than the allowances in your contract sum. So again, it works both ways. You should be put back in the position you would have been in if the contract had been performed. The second heading here is the prelim thickening. Now, this is where you require more supervision as a result of changes made in the contract. Again, those changes not being your responsibility. I mean, it's not a case where the contractor decides to make changes unilaterally. I mean, you're not going to get a thickening claim, a thickening application off the ground then, because you've made changes for whatever reason. You could be seeking to mitigate a delay you might be responsible for. So again, it's important to understand, why the thickening is occurring, and obviously the the party that you're submitting your application to is ultimately responsible for those changes. Now, thickening again generally means additional site supervision. You might have more work faces available, so you might have additional site manager and additional project manager, additional site engineer, because can happen as well. So again, it's understanding the two, but just to remember the two different headings, and they mean very different things, but they often get confused with each other. Is one is prolongation, and that is just where the program is longer, and the thickening then is where you just have more resource as a result of changes which have been imposed on you by your clients. So that's probably enough on preliminaries. Next one is general disruption. So this is where you have your as planned versus as built. So this is where you're saying, so this is how I plan to carry out the work, and this is the as built, and what you're trying to do there is show your disruption, and generally that does result in an application for an extension of time. Now, general disruption, I mean, if you're, for example, this is the one that gets commonly confused with variations, because very often it's the case that if the work has been disrupted, I mean the work that you're still doing is basically that which you signed up to do under your contract. And as a result of the disruption, then you frequently would experience reduced outputs. Now, in such circumstances, you do need to bear in mind that that is catered for under your variation clauses, because the variation clauses say that if there's a change in the conditions, then you should be entitled to a fair allowance on top of your bill rates. So do bear that in mind. Don't, not to always go for loss and expense in such circumstances. Do bear in mind the variation clause again, because here, I mean, with a measured mile, you can apply a measured mile to a variation or to loss and expense. The measured mile basically means that you take a period where your contract works went as planned, and you compare that then to a period of time where your contract works were impacted by changes which have been imposed upon you by your client. And basically what you're seeking to recover is that reduced productivity. So a very worthwhile principle to understand is the measured mile, and how that applies, because it will make your life an awful lot easier if you can use such an analysis from the beginning to make sure that you recover either your fair allowance under your variation clause or your additional costs under the loss and expense clause. Either way, you're recovering it. But that measured mile and understanding of that is key to such recovery. So again, your non-productive time, generally what we're talking about is plant and labor. I mean, any of this disruption is not, I mean, by and large, it shouldn't affect your, material costs. I mean, you may have more, part load charges, just say on concrete wagons, for example, or you may have more deliveries because of the fact that, you haven't been able to, the progress hasn't been as good as intended, and you might have restricted storage space on site. You might have some material costs at that point, but generally we're talking about labor and plant here, and that measured mile analysis is key to understanding the differences. And again, what you're saying is that is your additional cost that you need to put you back in the position you would have been in if the contract had been properly performed. So again, the importance of the Robinson and Harman, and I do keep repeating it, but it's a very important principle to bear in mind when making your applications. Head office overheads and profit. this is this is one that does cause a lot of dialogue. It's usually done on a formulaic basis. The most common ones you see are Emden formula, Hudson formula, or the Eachley formula, which is very popular in America. But those three generally. I mean, there are more. There's a lot of these, but the principle is quite similar throughout. I mean, and the reason this does get talked about because it does generate, once you run it through the formula, it does generate quite a significant number. So it's very common that you could have an application for loss and expense, and recovery of head office overhead and profit could be, in value terms, could amount to half of your application. So it does get spoken about. Look, the courts have approved it, so I mean, by all means, you should be applying for it. My experience has been that it's one that does get negotiated as part of the settlement. But by all means, it's definitely one that you want to have in your applications. Also recognised and I suppose approved by the in the Society of Construction Law, the delay and the delay in destruction protocol. So have a read of that. That's a very good resource as well if you want to understand more on how to apply for this, because it does go into it in quite good detail. Finance charges. So Minter told us that finance charges, these arise as a result of the claimant being kept from their money. So basically, when loss and expense typically occurs, you will have increased costs, but you won't be realizing the value until much later. So what you're saying is that you're entitled to interest on a result. Interest on those interest on the money that you've been kept away from, basically. So where you've had the costs, you've spent the money, but you may not realize the value until much later on. And so what you want to do is be able to go back into each of the individual payments, assess what your loss and expense was at the time, and calculate your finance charges as a result. That's absolutely fine, and something that should be done in loss and expense. Obviously the finance charges should not be too remote. But again, if you apply that logic, understand the events and when the money was spent against when it was recovered, and apply interest on the period in between, should be successful. Okay, so and finally under this section is the cost of collating the claim. So generally these costs, they're generally negotiated. What you want to do is see if the other side has been unreasonable in their conduct. I mean, had they been more reasonable, could reduced costs have been spent? Case very much dependent on the facts. But absolutely, I mean, if you're submitting an application, something I believe that should be in there, and always one, for discussion when you get around to agreeing the numbers and reaching a deal on these issues. So look, what proof needs to be provided? So it's what's reasonable in the circumstances. Sometimes it can be. Sometimes you might need to submit invoices. You could also need to submit pay slips, particularly that occurs where like I was saying under the prelim items, where you apply for those at cost, so you're going to have to so you may have to put in pay slips to show that that's actually the cost that you have incurred. You may also need to open up your ledgers. I've had that experience in the past where a client came to the offices to review ledgers. It was a very long day. It's not a very nice experience, really. But in the circumstances, we did agree that it had to be done because the client had a major issue with the employer, and the case was inevitably going to end up in formal proceedings. So yeah, it just shows you the lengths that you may need to go through, and some of the hoops that you need to go through in order to recover your sums. I mean, we were successful in that, but yeah, not a particularly pleasant experience. Yeah, that day when our client visited the offices, we had a computer down in the basement. We made him some bad tea all day, and we were basically just doing as much as we could to try and get him out of the building as quickly as possible. Look, it's par for the course, I think, in such circumstances. But it does happen. And look, you got to give them what's reasonable. So in that case, it was reasonable. So it just shows, as I said, it just shows some of the lengths that you may need to go to prove these things, and to be successful in your loss and expense, which is ultimately where you want to be. Okay, so what to do if you encounter loss and expense? So you need to act quickly. Prerequisite is to understand what the contract says, understand the liability point. Very important. Without that, you won't get your loss and expense off the ground. So key is to understand the liability point and your contract. What does it say? Are there any condition precedents? So if there are, basically make sure you're submitting your notice on time, because if you don't, you can be time barred. They do bite, so do be very very mindful of that. Is the event a relevant matter? If it is, attach the loss to that head of to that relevant matter. So it's key. So it's very clear where you deem this additional entitlement to come from. Similarly, is the event a variation, and if it is, as we're saying in the hierarchy of of areas in your contract where you should be recovering these costs, is go on, have a look at the variation clause, have a look at the valuation clause under your variations, because it could possibly just be a simple case of a fair allowance for a change in conditions. So just I would suggest look at the variation first and then go for your loss and expense. Just one, I think, don't call it a claim. I mean, I think that's quite a when you say claim, it's quite emotive. I think you just say application, or it's an entitlement under the contract. I mean, claim almost has is synonymous with something that people don't believe you're entitled to, and if you get your loss and expense and your causation right here, then it is absolutely something you're entitled to. So that's just this is a point from my own experience to bear in mind. And finally, just remember your duty to mitigate your loss. That's ongoing. That's ongoing in relation to loss and expense, in relation to extensions of time. So it's not just a case of, oh, we've been delayed down tools and we get it back off the client. That's not the case. You got a duty to mitigate. Be proactive with your client, and that's ultimately what's going to keep the relationship and help you to resolve matters at a later point in as much as possible, and give you the highest possible potential to be successful in your application. So yeah, I think that's pretty much it. So just a brief recap is obviously looked at what is loss and expense, how does it arise, understand your liability, understand what the contract says, remember Hadley versus Baxendale as well. And then obviously we looked at the the quantum points, the typical heads of your loss and expense, that you are seeking to recover. And just a final message with this is always bear in mind the golden rule. You're looking to be put back in the position you would have been in had the contract been properly performed. That's a helpful message to bear in mind when making your application for loss and expense. And ultimately that will give you it's very important when trying to realize the best possible outcome in your application. So I'm going to wrap up there and hand you back to Julie. So yeah, we'll take any questions that you may have now. Okay, thanks.
That's great, Conor. We do indeed have two questions, and the first one that's come in is, what is the approximate percentage for an approximate quantity to be considered accurate, i.e. not entitle a claim? What is the status of provisional quantities?
The status of provisional quantities, is that they're exactly that. They are provisional. They are approximate. So there's various reasons why you know, why the quantities cannot be accurately measured in, you know, in the contract. So it very much depends on a, you know, on a project by project basis. I mean, it's as well. It's very hard to say on a like. There's no general rule, and you know, insofar as saying, okay, well, if your approximate quantity is out by, say, 10%, that, you know, that triggers loss and expense. You've got to look at it to say, you know, whether it hasn't had a material difference on what my contract intent was. Because if it, you know, and if it has, then you know, have you incurred additional cost as a result? And if you have, then, I mean, it could be very minor, but if you haven't incurred additional cost as a result, then that's where the loss and expense clause comes in. So it very much depends on, on the individual contract itself. But the key point is to remember, you know, whether you've incurred additional cost. If you haven't, then you're not going to have an application for loss and expense. If you have, that's where the loss and expense mechanism and those relevant matters kick in, and that's where you apply them. And if you can demonstrate it, then you're entitled to it, and you should be able to be successful in your application.
Okay. To claim for loss and expense, does there need to be a relevant matter that the L&E is linked back to, or can this be linked back to change, alteration, or modification of design, quality, quantity of works? Versus witnesses, they're assuming that not all changes are relevant events.
Yeah, good question. So, you know, loss and expense, when you look at, like, I generally use JCT references because that's the most popular. You know, so loss and expense, if you look at loss and expense, you have those typical, the 5 grounds, the 5 relevant matters. and I mean, absolutely, you want to be linking your application back to one of those 5 grounds. Now, the first ground there is a variation. So, and that's where, on the second line of this question, is where you're saying about alteration or modification of the design, quality, quantity of the works. So in those circumstances, I mean, you're talking about a variation, you should be looking at the valuation rules under your variation clause in section 5. And basically picking up the fair allowance, or, you know, basically trying to prorata some of your rates in the bill of quantities as much as possible, because that's what the contract requires you to do. And then if you think about your loss and expense as the residue, then, you know, treat the loss and expense as anything which has not been recoverable under your variation clause, and that will ensure that you are treating it properly under the contract. And as I said earlier, you can have, you know, an event that is part variation, part loss and expense. But if you can understand those principles and understand that application, then, you know, you should be picking up, you will be picking up all of your costs. There's no reason why you shouldn't be successful in doing so. The final line here is, I'm assuming not all changes are relevant events, is that, I mean, relevant events obviously relate to time under section 2, and, you know, in relation to an extension of time. I mean, it won't be relevant events. Changes are not relevant events if they basically haven't, you know, if they haven't delayed the project. Well, they can be relevant events, but they're immaterial because they won't have delayed the overall completion date, which is why you want an extension of time. So it's just, I mean, it's just a separate point to the, you know, to the relevant matter and loss and expense. So yeah, not all changes are relevant events, because, as I said earlier as well, the contractor can make changes, which, you know, that's not going to be a relevant event, because if he decides to make a change that unilaterally, then he's not going to be entitled to an extension of time for such change. And the reason why he would make such a change, you know, varies. I mean, he could be trying to mitigate his own losses. And you know, if he's doing that, then he's not going to be entitled to an extension of time clause. So yeah, you're right to assume that not all changes are relevant events. It does, you know, vary based on based on the circumstances and the facts in each individual case.
Okay.
Okay.
To mitigate loss, is the contractor entitled to recover money as part of an L&E application?
Yeah, is the contractor entitled to recover money? Yeah, I mean that's what I mean. Loss and expense is, with loss and expense we are trying to recover money, because what we're saying is that changes have occurred, your client is responsible for them, and you've incurred additional costs which you're seeking to recover. I mean, your duty to mitigate loss is to make is to take reasonable steps to avoid further loss and expense, or that kind of down tools approach where you're saying that, oh well, a change has occurred and now I'm going to go after the client for everything that has happened here, and if if that results in additional costs to your client, then those surely will be recoverable as well. Well, no, because the duty is to be proactive in coming up with solutions here, and also just to mitigate it as much as possible. Any other approach is just not sensible, or is not going to be helpful in the scheme of things. So yeah, so the duty to mitigate loss applies equally to both loss and expense and extensions of time. And do bear it in mind whenever making applications, because if you haven't done that, then your client may have defense against you as to why you're not entitled to an extension of time or loss and expense in those circumstances. So be very careful, be very clear on your duty here, because it is very important and really underpins the principle of pretty much all construction contracts.
Okay, another question just come in. How would you attempt to settle loss and expense if contractors are unable to provide proof or evidence that they have incurred actual loss?
Yeah, great question. How do you attempt to settle loss and expense if they're unable to provide proof? I mean, again, without sounding like a typical solicitor, is like, it can depend on the contract. It depends on the circumstances. I mean, I'd be curious as to why these additional costs could not be demonstrated in any way, shape, or form. And I'd really scrutinize the detail here. I mean, ultimately what you want to be thinking is, I mean, if I can't settle this, then, well, what would the views of a third party be if they, if the matter was to be referred to them? I mean, because if a contractor is making an application and he can't demonstrate any loss, then it's very difficult to make an assessment of that and to be, fair and reasonable on all of those terms that we use. I mean, because if it's not genuine, then how can they prove there is a loss? I mean, I think you got to drill down into each of the individual heads of claim that have been submitted to you. A typical, like a classic one might be where guys, if just say labor. I mean, just say you had a prolongation claim and or a prolongation application, and you can show that a guy was being paid X before the 1st of January 19, and he was paid Y following the 1st of January. I mean, and that's proof of loss, because as a result of the project being prolonged, that person remains on site, and also the fact that he's now costing me more also. So I think you just really got to drill into the detail, and just grapple and ask reasonable questions to provide invoices. I don't think it's unreasonable to expect invoices in a lot of circumstances to show that the costs have actually increased. So again, it's what just look at the heads, be reasonable, and just ask the questions to show. Just really be clear, I think, as well on what you're actually looking for. Like, don't just deny the claim outright because he hasn't given proof. I mean, the onus is on there is an onus there to deal with it by the client, and I mean, to be asking reasonable questions. I mean, if you ask reasonable questions and the proof still isn't coming forward, then I think you're going to have a good chance of successfully defending such an application, because they simply haven't proven it. I mean, it's very hard to value something that hasn't been proven. So just be reasonable with it, drill into the detail, and if you do all of that, I think you stand in good stead to basically be able to successfully defend any loss and expense application.
Okay.
Yeah.
Another question just coming. How do you apply for a loss and expense under the JCT form of contract? Would it be in the form of a notice that the contractor states as a result of relevant matter X, which was dealt with under instruction Y, we believe we have an entitlement to a loss and expense?
Yeah. So loss and expense, like there is a section, loss and expense section in JCT contracts. It's in section 4, usually between section 4.15 to 4.20, roughly. That's where it's contained. It actually tells you there what to do, and the first part of a loss and expense application is to submit a notice, because what you're doing is you're communicating the fact that circumstances have changed. It links to a relevant matter. You're responsible for the relevant matter. I'm going to be looking for additional cost as a result. So that notice needs to be that notice is very important. Now, you can submit your particulars associated. So that's where you go into more detail to explain what's happened, and also to demonstrate the value. Show the exact amount of loss and expense that you're looking to recover. But the key point is that submit the notice, and now you can submit that particulars at the same time, or you could submit it within a reasonable time thereafter. I think it's better to get the notice in, because you don't realize how complicated the particulars can be, and if you haven't given them notice, then the client won't be expecting it. And especially if you have condition precedents, you don't want to be having to submit a notice and your particulars at the same time, because there's a lot involved in preparing that. So advice is to submit the notice first of all. That gets it off the ground. Cite what's happened, cite the contract clause as well, or else just basically use the language in the, if you don't want to use the exact number, so say under clause 4.21, we're treating this as a relevant matter. If you don't want to do that, then just use the language in the clause itself that shows the client what grounds you believe you're entitled to this loss and expense. And yeah, submit the particulars. I mean, and there you go. I mean, they're the two key points to remember when you are applying for loss and expense under your JCT contract. So yeah, that's all I can advise up there.
That's brilliant. Thanks, Conor, for those.
Okay. No problem. I think we might have broken the record for the amount of times loss and expense has been said in a webinar today, Julie. I
should be on to the Guinness Book of Records.
Yeah, I think so.
Okay. Well, that's all for today. Obviously, the video of this will be up on the website, our YouTube channel, and on our website if you want to check how many times loss and expense has been said. I'm feeling that's what Conor will be doing this morning. In the meantime, thank you all for joining. Have a great day at work, and we'll see you all again soon. Stay safe, and thank you, Conor, very much appreciated.
Thank you, Julie. Speak to you soon, okay?